Hello, YouTube. I'm Vince White. I'm an employment attorney, and we have a question from YouTube user Jay Hefner 4 days ago. And I told him or her, I don't mean to assume gender. I apologize. I said that I'll create a video response last Friday. Well, it is now Monday the 11th, and I have not created a response. And this response is not going to be posted until Wednesday. So, my apologies. But I am creating a response right now, and the answer to the question will come after the question. Let's read the question first. A little ahead of myself. What can an attorney do if a client has an active lawsuit and is still working for the employer, and the employer has retaliated against the employee with clear-cut evidence? Could that speed the case up? Okay, so many things the employee's attorney could do, because that is a retaliation claim. And retaliation claims can be like lottery tickets. Nobody knows what they're worth. Nobody's positive they'll win, but they can be worth a great deal with the right jury and the right fact pattern. So there's a lot of things going on there. We have a lot of videos on the channel about retaliation claims. I highly recommend thumbing through the channel and watching a few of those videos if you are facing workplace retaliation. Retaliation claims can be lower risk and potentially higher value than underlying discrimination claims. And you don't have to win the underlying discrimination claim or sexual harassment claim to win the retaliation claim. That's very important. There's a lot going on there, and you should check into that. Now, in terms of what you can do, so the employee is still working at the employer, and there's retaliation going on. Depending on the venue where the case is pending, you can either amend your complaint to add the retaliation claims, or you may have to file a new charge with retaliation claims. And this depends on the rules and procedures of the court or the venue where your case is pending, right? There's lots of different places: federal courts, state courts, arbitration, state agencies, county agencies, federal agencies. There's all these different places, and they all have different rules. So generally what you're going to want to do is either amend to add retaliation claims or file a new claim. Now, if your goal is to maximize the value, that's what you do. If your goal is to protect the job first and then maximize the value, well, then the attorney for the employee might call up the attorney for the employer and say, hey, your idiot client's doing it again. They're retaliating. You want to triage this? You want to make sure this case doesn't get any bigger than it already is? And defense counsel say, they're doing nothing of the sort. But I will have a conversation with my client right away. Because, of course, defense counsel's number one job is triage. Make sure the case doesn't become more expensive for her or his client, right? So they're always going to deny. That's what defense attorneys do. But they're going to go to their client and be like, listen, you moron, what are you doing? Why? One, you're making my job harder. Two, you're going to end up paying me more because now we got another claim coming. Three, this claim is spiraling out of control. It is getting bigger. And it's because of your idiots. Your idiots on the ground are retaliating. You got to stop them. If they don't stop, you got to fire them. Maybe we should put this person out on paid leave so that they can't be retaliated against anymore, right? That's very common. That is one of the main activities that defense attorneys engage in. The training and the ending of retaliation. Because an underlying employment case, we might know generally what that could win at trial, right? Nobody really knows what a retaliation case could win at trial. It's way too uncertain. It's way too hard to calculate those damages. It's like trying to guess what a jury is going to think about a trial we've never seen. And then these people we don't really know, we haven't even met, we haven't even selected yet, after they see this trial we've never seen and all this testimony we've never seen, they're, as people we don't know, going to pick a number from a hat of what they believe the damages in the retaliation case should be. There's some guidelines that they might follow, but still, that's a pretty wild endeavor, and it's really hard to guess what that number might be. So, Employment Defense Counsel's number one job is try to make that not happen. Try to avoid that. Cut that off, right? Retaliation claims can push settlement, can speed up cases. They can also slow down cases. Sometimes, with a retaliation claim in play, defense counsel and the employer won't negotiate because they don't want to put value. Often people will refuse to negotiate the value of a retaliation claim. And it's because it's very uncertain. We don't really know what the value is. That's problematic because many employees, many plaintiffs are going to say, Why would I settle my case just for the one discrimination claim or the one sexual harassment claim when I have this other retaliation claim, right? And as the plaintiff's attorney, we say, yeah, so it's your call. It's your call if you settle. They're not going to give you money for the retaliation claim. If you settle, you're settling all the claims, but you're only getting paid for the discrimination claim or the underlying sexual harassment claim. They're not going to pay you in settlement for the retaliation claim. So your choice is embrace all the risk of trial to try to get the value of that retaliation claim, or settle your claims, but only for the value. You're settling all of your claims for only the value of the underlying claim, not the retaliation claim. That is a tough call. Now, most plaintiffs will end up settling, just based on my experience. Often, it's kind of heartbreaking because I'm sitting here and I'm like, well, that retaliation claim could have been really valuable. It's really sad. But we do what our client wants, right? If our client says, well, I only get one of these and you get hundreds of these per year, and, money in hand, is better than all this risk of a trial in front of a jury we haven't even met yet, then they're making the right choice for them. And our job as plaintiff's attorneys is to effectuate what they need, what they want, what their choices are, right? They're the shot callers, they're the decision makers, the clients are. We're just the monsters for hire, right? We effectuate the decisions of our clients, and any employment attorney that's not doing that, any employment attorney that's giving you a hard time or trying to force you into a settlement or trying to keep you out of a settlement, it's not their job. Now, it is our job to be like, hey, you got to think about X, Y, and Z, and we don't think you're going to get that much. And it's a lot of risk here, right? We have to have those conversations, but we never say, you have to do this. We say, this is a bad idea, but we're going to do what you tell us. That conversation happens a lot, right? But never, you must do this or else. That should not happen. And I know there are plaintiffs' attorneys who do that, and that is a bad thing. They're doing a bad, unethical thing, in my opinion. And if they do that to you, you should consider speaking with the Bar Association. Like and subscribe if this video was helpful. I hope it was. And I will track the comments for follow-up. Take care.